welcome to a fresh episode of Legal Wrangle on direct taxes. We bring you 4 latest and very important judicial decisions, including the one relating to the CBDT Circular, fixing monetary limits for filing the revenue's appeals before higher judicial fora. In the present case, the revenue had challenged the decisions of various high courts, which took the view that the circular number 1979 related to the monetary limit was applicable to pending appeals as well. The Government of India had framed the national litigation policy to reduce pendency of cases. Accordingly, the CBDT had issued an instruction in 2011 directing that appeals were not to be filed before high courts where the tax impact was less than Rs 10 lakhs. Such instruction was in supersession of the earlier instruction number 1979 where the tax limit was of Rs 4 lakhs. The former instruction was stated to have a prospective effect. Thus, pending cases in the High Courts filed prior to the instruction number 1979 but having tax effect of less than Rs 10 lakhs were required to be interpreted on merits.
However, the High Courts of Karnataka, Bombay, Madhya Pradesh and Delhi took the view that the circular number 1979 was applicable to pending appeals as well. On the other hand, the High Courts of Madras, Kerala, Punjab, Haryana and Chhattisgarh took a contrary view.
On appeal by the revenue, the apex court held that, firstly, the CBDT circular prescribing monetary limits for the revenue to file appeals to higher courts will have retrospective application to even pending cases. Secondly, the circular should not be applied by the high courts ipso facto when the matter has a cascading effect. Thirdly, the matter was squarely put to rest, taking further care of the interests of the revenue by the order passed by the 3 judges bench of this court in Surya Herbal Limited case, which had put 2 caveats even to the retrospective application of the circular. Hence, the appeal was settled against the revenue. Let us now proceed to our second case.
The assessee company manufactures synthetic yarns and claimed deduction under Section 43B in respect of the balance amount in the personal ledger account at the end of each AY. To avoid double taxation, the assessee added the same as part of the taxable income in the immediately succeeding accounting years. Such practice, consistently adopted by the assessee, was all along accepted by the revenue except for the 4 AYs under consideration.
The revenue objected to such practice and stated that though excise duty was levied on manufacture of excisable goods, actual payment of duty was at the stage of removal. The advance duty paid in the personal ledger account was adjusted from time to time against clearances or removal. It was further submitted that unless such clearances were made and excise duty was debited from the advance deposit, there was no actual payment of duty to entitle an assessee to Section 43B benefit.
Later, the High Court held that the amount of advance deposit did not represent actual payment of the duty so as to entitle the assessee to the benefit of deduction under Section 43B. Further, the jurisdictional High Court also allowed the assessee's writ petition with regard to the similar issue.
On further appeal, the apex court held that, firstly, once the deposit of central excise duty in the personal ledger account is made, the same is adjusted against the duty payable on removal and balance is kept in the account for future clearances. No withdrawal from the account is permissible except on an application to be filed before the Commissioner, who is required to record reasons for permitting an assessee for such withdrawal. Secondly, the purpose of introduction of Section 43B of the Central Excise Act was to plug a loophole in the statute which permitted deductions on accrual basis without the requisite obligation to deposit the tax with the state. Thirdly, on the basis of mere book entries, an assessee was entitled to claim deduction without actually paying the tax to the state. And lastly, the advance deposit of central excise duty constitutes actual payment of duty within the meaning of Section 43B, and therefore the assessee is entitled to the benefit of deduction of the said amount. Hence, the issue was resolved in favor of the assessee. Let's now proceed to our third case.
The assessee club filed nil return, claiming to be a mutual concern. On assessment, the AO noticed a surplus of income over expenditure, including interest income. Further, to determine the assessee's claim of being a mutual concern, the AO examined the Memorandum of Association and the bylaws of the club and noted that its control management was vested solely in the Haryana Urban Development Authority. Thereby, the AO concluded that the assessee was an extended arm of the Huda.
The assessing officer further observed that the contributors to the funds were neither entitled to participate in the surplus nor otherwise had any say in the management, including finances of the club. The AO also noted that the club facilities were extended to certain non-members against payments made by them. The AO inferred that the club was also involved in profit-making activities from third parties. Thus, the AO sought to tax the entire surplus shown.
The issue before the tribunal was that where a club received surplus amounts via contributions or from the value of some facilities availed by the members of the club, whether it was liable to pay tax on such surplus amounts. On hearing the matter, the tribunal noted that, firstly, there cannot be a straitjacket formula to say that in every mutual concern, the members must be entitled to a share in the surplus. Secondly, as observed by the Supreme Court in many cases, it is difficult and vexed question as to at what point of time the relationship of the mutuality ends and that of trading begins. Since the affairs of the assessee trust are controlled by the serving of vices of Huda, hence it has to pass through greater scrutiny as the chances of it crossing the line between mutuality and commerciality are very high. Thirdly, the revenue could not point out the taint of commerciality in the contribution, management and application of the surplus collected through contributions and subscriptions from the members for the price of the facilities availed by its members. Hence, the same cannot be said to the taxable income of the society. Lastly, the assessee is entitled to the benefit of the doctrine of mutuality in respect of the surplus amount received as contributions or price for some of the facilities availed by its members. However, the amount of interest earned by the assessee from the fixed deposit in the bank will not fall within the ambit of the mutuality principle and will therefore be eligible to income tax. Hence, the issue was settled in favor of the assessee. Let us now proceed to our final case.
In the present case, the petitioner challenged the validity of the ICDS notified by the CBDT and raised some major issues as to whether amendments to section 145 clause 2 enables the executive as a delegate of the legislature to change the basic principles of accounting recognized in various provisions of the Act. If so, can the concept of prudence be done away with by an amendment in the provisions of the Act? The petitioner, being a society of advocates, chartered accountants, company secretaries and other professionals, argued that in the guise of delegating powers to the central government to issue ICDS, what has effectively been done is to delegate the essential legislative power to amend the provisions of the Act, especially those affecting the chargeability and computation of taxable income. The central government cannot be conferred with such unfettered powers by the Parliament in the guise of delegated legislation to notify ICDS modifying the basis of taxation, which otherwise, if at all, can be done only by the Parliament by making amendments to the provisions of the Act.
The High Court held that, firstly, the amendments of Section 145 permit the central government to notify standards for income computation but not to bring about changes to settled principles as laid down in the judicial precedents which seek to interpret and explain statutory provisions contained in the Act. If such power is permitted to the exercise by the central government, then clearly it would be an instance of unfettered power in the hands of the executive, which is unguided and uncanalized. Secondly, Article 265 of the Constitution of India states that no tax shall be levied or collected except under the authority of law. The power under Section 145 Clause 2 of the Act cannot permit changing the basic principles of accounting that have been recognized in the various provisions of the Act, unless of course corresponding amendments are carried out to the Act itself. Such amendments would be consistent with an acknowledgement that as far as the Act is concerned, changing the method of accounting for computation of taxable income would partake for an essential legislative function. Thirdly, to that extent, Section 145 Clause 2 as amended has to be read down to restrict power of the central government to notify ICDS that do not seek to override binding judicial precedents or provisions of the Act. The power to enact a validation law is an essential legislative power that can be exercised in the context of the Act only by the Parliament and not by the Executive. If Section 145 Clause 2 of the Act as amended is not so read down, it would be ultra vires of the Act. And lastly, in the present case, there are no guiding principles in Section 145 Clause 2 of the Act for the scope and ambit the delegated power of the central government. In order to preserve its constitutionality, Section 145 Clause 2 of the Act as amended is required to and is hereby read down to restrict power of the central government to notify ICDS that do not seek to override binding judicial proceedings or provision of the Act, and the verdict goes against the revenue.
With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for our programs on topical issues. Thank you for watching.